right, we're moving right along. What was my next one? Oh, yes. Okay. The next bill we're going to hear is H813, Pretrial Integrity Act. And Representative Bradford.
Thank you, Mr. Chairman. Yes,
The chair recognizes Representative Bradford to explain the bill.
Thank you, Mr. Chairman. I also have Representative Abe Jones, who is on this bill with me. This is House Bill 813, Pretrial Integrity Act. It's really a victim's right bill. It's a bipartisan bill that provides for certain felonies that a judge, and not a magistrate, review the right to pretrial release and set forth the conditions of the release. Furthermore, it requires that a judge to determine pretrial release conditions for any defendants that are repeat offenders that have been charged with a new offense while already under conditions of a pretrial release for a prior offense. This bill is supported by the City of Charlotte, the Mecklenburg County District Attorney and his office, the Charlotte Police Chief, the North Carolina Conference of DAs, North Carolina Association of Chiefs of Police, and North Carolina Police Executive Association. It did receive a 92 vote favorable on the House floor. Mr. Chairman, I do believe there's a technical amendment that was brought forth by the Administrative Office of the Courts that I think Senator Britt's going to run.
Senator Britt, did you wish to amend the bill?
Yes, Mr. Chair. You should have this amendment in front of you. It's H813-ACU-75. Again, purely technical, amends the bill on page 2, lines 20 through 29. If you have any questions about the amendment, staff can address them. But it was didn't change any of the substance of the bill, just changed some technical language and more clarifying language as needed by AOC.
Thank you, Senator Britt. Are there questions or comments on the amendment from the committee members? I'm not seeing any lights go off. All right. All those in favor of the amendment, please indicate by saying aye. Aye. Any opposed? The ayes have it, and the bill as amended is back before us. And you wish to address any further comments?
Yeah, Mr. Chairman, right before committee, a potential amendment was brought to me by Senator Muhammad, and we've already talked, and because I have not had a chance to read it, I just got it. He may have some comments to it, but I told him I'm happy to read it and review it with all the folks I've been working with, including yourself and perhaps Senator Britt. So I just wanted to at least acknowledge that I realize there may be other changes coming, but I didn't want to try to speak to something I just saw.
Fair enough. Fair enough. All right. At this time, the bill is back before us as amended. Questions or comments from the committee members? Senator Muhammad, did you have anything you wanted to address?
Thank you. Thank you, Mr. Chair. A couple of questions. I think, first of all, let me just start by thanking Representative Bradford and the other bill sponsors for being able to listen to me and hopefully work with us on this bill. But I just want to have some, just want to understand the constitutionality of it, because obviously we're deviating from what we've been doing now a little bit. So I just want to check with staff a little bit if they can talk about if there's any potential Eighth Amendment violations or anything, based on any type of judicial precedent as far as detaining people for pretrial purposes on specific charges. Because it's my understanding from the United States Supreme Court that those have to be individualized determinations, and I'm hoping we're not just setting ourselves up for more litigation with something like this. So I don't know if somebody from staff can answer that.
Why don't you reframe your question so that staff can address it more specifically?
Thank you, Senator Noon.
What you're
so
driving at.
My question is can staff speak to as far as the constitutionality of detaining individuals like the bill does for potentially up to 48 hours, potentially waiting for a judge to review that process? I just want to understand that process and make sure that we're in line with the law and the Constitution.
Rob?
Sure. Robert Ryan, Legislative Analysis. Ultimately, any constitutional determination about any law the General Assembly passes can only be determined by the courts. As Senator Muhammad mentioned, I think the Eighth Amendment addresses excessive bail, saying that no excessive bail should be set in any case. And then the Fifth Amendment is the Due Process Clause, and that talks about substantive due process in a case and whether or not generally a individual can be detained before trial. And there's been Supreme Court cases on the issue, but nothing binding on the General Assembly.
Senator Mohammed?
Another question for staff, Senator Newton. I don't know if staff can explain this to me or maybe confirm. It's my understanding in 2015, this General Assembly gave judicial officials the authority to double the bond when somebody's on pretrial release and they pick up a new offense. Is that correct?
Rob?
Yes, sir. Let me find the site because I. So that statute is going to be GS 15A-534 sub D3, and that reads, when conditions of pretrial release are being determined for a defendant who is charged with an offense and the defendant is currently on pretrial release for a prior offense, the judicial official may require the execution of a secured appearance bond in an amount at least double the amount of the most recent previous secured or unsecured bond for the charges. And if no bond has been yet set, it shall be at least $1,000.
Thank
Follow
you.
up, Senator Mohammed?
Thank you. So my question for the bill sponsor. So Representative Bradford, can you help me understand why you don't think that might be satisfactory already, since we have the double bonding opportunity by a judicial official?
Representative Bradford?
Yeah, so, I mean, this is about magistrates making decisions versus judges. And so this bill just ensures that for certain offenses, both in initial arrests and pretrial release, as well as repeat offenders, that it actually goes to a judge and not a magistrate. And so that's really the intent of it. I think it's important to note that the 48-hour period that you allude to, it is an up to time. It's not a hold. It's up to. And after speaking to the district attorney from Mecklenburg County, many of these are heard within hours, actually. But we just wanted a backstop, sort of like a shot clock, so to speak, for a magistrate to be able to pick up the ball if a judge was not able to get to within 48 hours. But it's up to, and it's not a hold.
Okay. Thank you.
All right, follow up.
Bradford. Yes. So this is more of a comment, Senator Newton. So Representative Bradford, like I said to you earlier, I didn't find out about this bill being in committee till yesterday because Senator Newton, the other Newton, was keeping me busy with elections bills this week. So I found out when I did, and I apologize to you that I haven't had a chance to have a conversation with you about it. But my understanding, I'm looking at the bill, and correct me if I'm wrong, based on when I've spoken to staff, it's my understanding that the bill has 18 specific charges which require a judge to review before bond is set. That's one part of the bill. And then the other part is that when someone's on pretrial release already for misdemeanor larceny and they pick up another charge for, I don't know, a simple assault, they would still wait up to 48 hours. If a judge is not available, then they would see a magistrate. Am I correct in the bill?
Well, I mean, I would just say that this bill is that for someone who is a repeat offender, they're already out on pretrial release, that if they are back, then instead of it going to a magistrate, it would have to go to a judge within 48 hours. Okay. So that's what this bill does. Okay. I hope I'm answering your question.
I just want to make sure
I
just want to make sure I'm understanding clearly that this is for any offense. So if somebody's on pretrial release for any offense currently, like I just said, it could be a simple assault. It could be a misdemeanor larceny. They're on pretrial release. Then they go and pick up a new charge while on pretrial release. It could be for failure to pay fare on a light rail in Charlotte, a local ordinance violation. They could potentially be detained up to 48 hours. Am I understanding that correct? Because that's my reading of the bill, and I think that was my understanding from staff as well. I mean, correct me if I'm wrong.
Oh, okay. Rob, can you opine on this? Can you clarify for us?
Yes, my reading of the bill is that it's, as Senator Mohammed explained, that if someone has out on pretrial release for any offense and then is rearrested for a new offense, subsection H would apply, and therefore a judge and not a magistrate would have to be the one to set the new pretrial release in subsection H.
Thank you.
Right. Thank you, Senator Mohammed. Yes, Senator Britt.
Senator Newton, if I can, just a couple comments. I first want to thank Representative Bradford and the others for working on this legislation. Current statutes state that certain crimes you're not entitled to any bond at all, and many crimes, even if you go before a judge to have your conditions of pretrial release determined, it doesn't mean you're getting out. What 813 seeks to do is take some of the more violent felonies and sex crimes and make those crimes that have to be set by a judge. If someone is out committing crimes on Friday night, they may have to stay over the weekend. Maybe anyone listening, hopefully, don't commit your crimes on Friday evening and you won't have to stay as long in jail, right? It's up to 48 hours. It's not a mandatory hold to 48 hours. We've got the elected district attorney here, Spencer Merriweather from Mecklenburg County. I've had a lot of folks from the business community in Charlotte reach out about this being an issue, and in other places around the state, of folks getting out, having a magistrate set a low bond, and they're right back out committing another offense again. So as an honorary 7th delegation member, how many Mecklenburg has now? 6. I stand with Mecklenburg County on House Bill 813. I support the law enforcement that's here from Mecklenburg County on House Bill 813. And move for favor at the appropriate time.
Thank you, Senator Britt. And in just a moment, I know we have some folks that have signed up to speak on this bill. Senator Mohammed?
So, Senator Newton, thank you, Mr. Chair. And this is just a comment, and I agree with Senator Britt. I mean, if it's for violent offenses, I completely understand. I commend the bill sponsors for working together with my own district attorney, Spencer Merriweather, on this bill and the rest of the Conference of DAs. I believe you do have some real issues and challenges with folks potentially being released for violent offenses. My bigger concern is the low-level offenses. We don't want to contribute to people's problems. I reached out to the school of government late in the evening. I'm so thankful for them and the resources they provide to all of our government branches. Almost over 80% of criminal charges in our criminal justice system in North Carolina are nonviolent misdemeanors. And most people would potentially assume that those low-level offenses are just charged by citation, but they're not. Oftentimes, people are actually booked and released on conditions. In fact, they worked with dozens of sheriffs, rural, urban, and suburban. They reached out to them and collected this data. Representative Bradford, and again, this is because you and I didn't have a chance to talk about it, so I'm just kind of trying to help explain it to you what my concerns are, is that the top 10 most commonly charged pretrial crimes, these are the most common crimes charged. Every single one of them almost is a misdemeanor. 7 of the top 10 are related to motor vehicle offenses. And those are offenses like, let me just tell you, driving with a license revoked for not an impaired revocation. That means if you couldn't pay your fines and fees and now your driver's license is revoked, you could potentially be detained for that. Speeding, misdemeanor larceny, no operator's license. These are the most prevalent, common criminal charges that individuals are charged with. So my concern is that when you have the bill, at least the second part, Representative Bradford, that opens that up for all offenses. So if you have a mother who ends up potentially allegedly stealing some diapers from Walmart, for example, she's on pretrial release now, then she doesn't pay the fare in Charlotte on light rail. She's going to be potentially detained up to 48 hours for the most minor offenses. I want my prosecutors, I want all prosecutors across the state and law enforcement to tackle their resources on serious and violent criminal offenses. We've heard time and time again with the budget that the district attorneys right now are overworked, they're stretched thin. My concern is when you have these low-level offenses now coming through our court system, you're going to see longer first appearances. You're going to need district attorneys there, public defenders there, other attorneys there, clerks there. Not to mention our own jails are potentially being clogged up with people sitting there for minor offenses, waiting up to 48 hours. And we're lucky in Mecklenburg County. My friends from the other parts of the state, they like to call us the state of Mecklenburg County, and we're thankful to have a little bit more resources. But I'm honestly looking out for your constituents in rural parts of the state who don't have those resources, who might potentially be sitting there for the most petty offenses with this piece of legislation. So, Representative Bradford, I would really ask you to consider. I work with Representative DA Merriweather on at least the Chapter 20 motor vehicle offenses to make that an exemption to it, because those are at least 7 of the top 10. But I would ask you to really consider eliminating the low-level offenses from being included in this bill so our prosecutors and law enforcement community can focus on the more serious and violent offenses and not divert those resources.
Thank you, Senator. We appreciate your concerns are well noted. We look forward to reviewing your amendment when it comes. At this time, we're going to move to public comment. So I know we have some people that came a long way to speak to the bill. So at this time, I'm going to call first Deputy Chief, I think I've got it, is it Brock, or I hope I'm not reading it wrong, Deputy Chief Brock of Charlotte-Mecklenburg, and after him, the District Attorney for Mecklenburg County, Spencer Meriwether. Good afternoon.
Hey, good afternoon. Thank you so much. It's Stephen Brochu.
I'm sorry, I was trying to read the writing. I apologize.
You know, in law enforcement, I get all kinds of names, and that was probably one of the better of all of them. But I'm a deputy chief with the Charlotte-Mecklenburg Police Department. I'm here on behalf of Chief Johnny Jennings and many law enforcement agencies. I just want to say thank you for allowing me to speak. Also, just some comments from our perspective. This legislation is developed to bring greater accountability within the criminal justice system. That is elevating from a magistrate to a judge, to a trained judge, the ability to make decisions on these judicial decisions for bond. Although this affects a small number of offenders, it addresses a chronic issue of repeat violent offenders. This is a victim-focused bill for public safety, all right, that also addresses a revolving door that officers are experiencing throughout this entire state, in that when they're making arrests, by the time typically they're making arrests, the offender is back out in the street only to re-offend. As was mentioned, this bill is supported by the North Carolina Chiefs Association, the North Carolina Police Executive Association, as well as private industry and Regional Business Alliance. So, thank you.
Thank you, Deputy Chief. And Mr. Meriwether? And thank you for coming from Charlotte. We appreciate it.
Thank you.
Yes,
Mr.
sir. You're
Chairman.
recognized.
I appreciate that. I'm grateful to you. I'm grateful to the sponsors, Representative Bradford and Representative Jones, for being here. I'm also grateful to my senator, by the way, Senator Mohammed, as well as the entire Mecklenburg delegation. I am proud of the fact that this bill was able to advance with unanimous support from the Mecklenburg delegation in the House. I did want to speak to some of the concerns that were raised by Senator Mohammed, and mostly I wanted to do that by just painting a picture for you. We have a person in our jurisdiction, I won't prejudice any particular trial by using his name, but a person in uptown Charlotte who pushes people into traffic. That person, every time that happens, is charged with a Class 2 misdemeanor. They are brought before a magistrate, and the magistrate sees a Class 2 misdemeanor, believes that that case is minor, that case is low level, and then dispenses of the release conditions for that person and releases them with the written promise to appear. At no point is that person able to hear the circumstances which are scaring people as they're walking in uptown Charlotte. At no point is that person able to hear the circumstances that is frustrating businesses that are lined up and down uptown Charlotte from people from entering into that place. And guess what people do then? They knock on the doors of their police chief and their DA. And so that's the reason that I'm before you today. That's the reason I hope this bill advances, and in whatever help that any of us in the Conference of District Attorneys can offer or the police chiefs can offer, as you continue to think about this, we certainly extend that to you. So thank you so much.
Thank you for being here. We appreciate your comments. The chair recognizes Representative Bradford for a closing comment, and then we have a motion before us.
Yeah, thank you to everyone for the remarks. Senator Mohammed, as I proactively said, happy to work with you. I just, you dropped something on me, and I know you had your reasons for doing it. I'm not critical of that. Of that said, there's a lot of people who've worked on this bill. Therefore, I think they have the right to weigh in as well. So you have my commitment to keep doing that, and look forward to this bill moving ahead. Thanks for listening.
Thank you. All right, we have a motion before us. Senator Britt moves for a favorable report on H13 as amended, rolled into a new PCS. Unfavorable is to the original bill with a referral to Senate rules. All those in favor, please say aye. Aye. Any opposed? The ayes have it. Thank you, Representatives. Thank you, Representative Jones. We are moving along.